The Illinois Supreme Court siding with the Pretrial Fairness Act. Good morning. It is Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. Of course, we were anticipating a ruling yesterday, and it came out right at 9 o'clock, where the Illinois Supreme Court decided that the Pretrial Fairness Act is constitutional after state's attorneys from across the state filed litigation against implementation of the law starting January 1st. And late last year, if you recall, a Kankakee County judge consolidating all of those cases and finding that the state's Safety Act and the Pretrial Fairness Act violated the Constitution on multiple grounds of separation of powers, but also the Victims' Rights Bill of Rights. So you had the Kankakee County judge make that ruling that it was unconstitutional, and then the Supreme Court had to essentially hold it from being implemented until they could deal with the issue. And then we had the hearing in March where you had both sides present in front of the Illinois Supreme Court, and also you've got the issue of being decided yesterday. And after it was decided, 60 days the court gave for it to be implemented. A lot of conversation about this yesterday from all sides, and you've got statements from the governor supporting the decision. You've got statements from the attorney general supporting the decision. You've also got statements from the Pretrial Fairness Network, a group of advocates who have been pushing for this. And one of the chief sponsors of the measure was State Senator Robert Peters, a Democrat from Chicago. And he laid out his applause for this being upheld by the state Supreme Court. Here's Robert Peters yesterday during a news conference held virtually with a whole bunch of advocates.
As someone who has been part of this coalition well before I was a state senator, I am truly honored to have been part of all of it. I remember the people who told us this was impossible. And may we stop having so many naysayers who are often left to history's dustbin. This is an historic civil rights victory that has become our state's version of Obamacare, a repeatedly disgusting fight by right-wingers who don't care about people's safety and play dirty politics with people's lives. I'm disappointed in those right-wingers. The only purge that happened was the waste of taxpayer dollars and time. Their attacks caused undue pain for those working class families with loved ones locked up due to being poor. This is about safety over wealth. This is about community over isolation. This is about hope over fear. This is about making history. And in Illinois, as you can see here, we had leaders who didn't run away from their shadows, but stood strong, arm in arm, with an organized movement that is making change.
So again, Robert Peters there, one of the chief sponsors of the Safety Act and the no cash bail provision. And really think about it, you are innocent until proven guilty. And what they're looking to address here is the issue of individuals who are innocent until proven guilty. Yeah, they've been arrested as a suspect in a crime, but they're innocent until proven guilty. And just because they can't afford a cash bail, the proponents of this say they shouldn't have to languish behind bars because that disrupts a whole host of things. So you have now another sponsor of this, State Representative Justin Slaughter. He sounded off yesterday as well and laid out some of the particulars about the Safety Act and things moving forward.
Safety, accountability, fairness, equity, and justice won for the people of Illinois. And now, on this great day, as trailblazers for the entire country, we usher in a more fair and just pretrial system. We restore the presumption of innocence. When we look at this mass incarceration crisis, it's important that we address overly punitive criminal justice policies that push individuals, mainly Black and Brown people, communities, deeper into our system. Provisions that deal with the transition period, the detention net, our dangerousness standard, willful flight, our statewide public defender program that we'll be rolling out. How will we deal with prompt remote hearings, warrants, trespassing and misdemeanor citations, electronic monitoring? How will we implement our speedy trial program and appeals, and so many other comprehensive provisions that will make ending cash bail an important ineffective.
So statewide, the first state to ever do so, ending cash bail after the Illinois Supreme Court upheld the Pretrial Fairness Act portion of the Safety Act. We will hear from the law enforcement community. I connected with the Illinois Sheriff's Association and also the Illinois Fraternal Order of Police. So we'll hear from them coming up, but let's hear from prosecutors who support the end of no cash bail in the state of Illinois. Here's Eric Reinhart. He is the state's attorney for Lake County.
Even individuals who are charged but are released for primarily nonviolent offenses or for nonviolent offenses, they'll have some of these conditions also. They will be required to come back to court. They will be required to follow certain rules. And this really mirrors the 2020 Supreme Court Commission that came out in April of 2020, where we had police leaders, we had prosecutors from across the state, we had policy leaders, we had advocates working on this April 2020 commission. I would direct members of the press to that April 2020 report, where it talked about nonviolent offenders not needing to be held. That if they were not a risk to the community, that people do not need to be held prior to trial. We have to recognize that it can take a while to get to a trial, and that we have to balance all that. I thought as Justice Slaughter said amazingly, that we have to balance the turbulence in people's lives when it comes to education, jobs, and housing that occurs when we incarcerate them unnecessarily. And what that commission said in April of 2020, I think that's such an important date, was that nonviolent offenders shouldn't be held prior to trial. But they can't have these conditions on them, these sureties, as Charlene said. And if those conditions are violated, judges absolutely have the discretion to put somebody in custody because they've been given their chance to follow the rules.
One of the main things of the arguments that the prosecutors brought forward challenging this was that cash bond is constitutional. And the state Supreme Court says, while a surety is constitutional, that doesn't necessarily have to be cash money. And that seems to be where the Illinois Supreme Court landed. Judges can give other kinds of sureties, like you can't be in contact with this specific person, you can't go to this specific address, you can't be found violating other laws. And if those sureties are violated, then they can be held. And that's something that the Lake County State's Attorney had to say. Cook County State's Attorney Kim Fox, she said that they're ready to implement this. They were ready to implement this from when it was supposed to go into effect on January 1st.
And so we had adequate staffing. We had, adequate time to prepare how the motions would go, training on our staff. We did repeated training of our staff of how to implement the new law. And so, as I said, on December 31st, we were ready. All of us were ready to go into that courtroom on January 1st. So what I can assure people is that on September 18th, we will be just as ready as we were on January 1st, that we have adequate resources to be able to meet the needs that are laid out before us. We have been eagerly awaiting this day so that the people of the Cook County State's Attorney's Office could implement this law.
So again, Cook County State's Attorney Kim Fox saying they're ready to implement it, and they've got all the pieces in place. Prosecutors across the states also saying they're going to comply with this. Even here in Sangamon County, State's Attorney Dan Wright says they will, comply with the order and implement no cash bail. But again, 60 days from yesterday, so now 59 days, no cash bail will be the law of the land in the state of Illinois. We'll hear from the law enforcement community, in particular the Illinois Sheriff's Association and the Illinois Fraternal Order of Police. Stay tuned. We'll get to that next here on WMAY. With Springfield's Morning News, I'm Greg Bishop. Follow me anywhere, Bishop on Air. Twitter, Facebook, YouTube. You can also email bishoponair@gmail.com. So we heard from the supporters of ending cash bail after yesterday's Illinois Supreme Court ruling uplifting no cash bail statewide starting September 18th. I connected with Illinois Sheriff's Association Executive Director Jim Kajcek, and he provided an initial reaction to what this ultimately means for the law enforcement community and for the public.
Well, I guess we'll go back to the process that was established that each of their individual offices, in terms of protocols that they were working on prior to the injunction being placed on at the end of 2022. So now we've got 60 days from today to, gather all of that information again, figure out, go back and work with the unknown, with the courts. I think there were questions about whether or not there might be some tweaks that were sent back I don't think any of us were terribly surprised that, disappointed for sure, but not terribly surprised that, in fact, the courts ruled the way they did, but we didn't know if there would be some level of modification. So now, take back out everything that we had before, work with our state's attorneys, talk to the chief judges. And if you remember back in the act that passed, or I should say the final trailer bill that passed and was signed into law in December, one of the things in there established a new process where petitions could be filed for those people currently in custody to have those charges, I shouldn't say the charge reconsidered, but their bail reconsidered. And that created a timeline, and I don't have that all off the top of my head, but it created, based on certain offenses, when those would be heard before the court. So now it's a matter of redeveloping that same system that they indicated is in place now and adjusting the timelines according to how they would have been set up at the first of the year from September 18th moving forward. So there's going to be an awful lot of work that goes on here. Obviously, we still have concerns, significant concerns like we have had all along about, people not necessarily being detained that ought to be, and how our communities are going to react to that.
So if you recall, the law that passed in early 2021 barely passed the House and Senate, but still was very much on its way towards implementation in early 2021. It had to be changed 2 or 3 times. The most recent change came in December of 2022, which narrowed down the detainable offenses because at first the concern was, well, this is going to let people out on second-degree murder or, arson or a variety of other violent crimes. And Democrats said that was, hyperbole, but they still went back and clarified things as to what was a detainable offense. So more from Jim Kychek about the resources that are going to be necessary, especially for those who may be repeat offenders who on a first offense get in, they get booked, then they're let out, and then they do another offense. Well, then you got warrants that are going to have to be issued and so on. He says that's going to increase the resource capacity for those law enforcement officers on the street.
Well, yeah, it's a good question. I don't know that we have all of I know we don't have all of the answers to that yet, but I think that the issue is going to be we're going to have people that instead of issuing warrants in a lot of cases, a summons to appear will be the case, and the process for us being able to deliver them, it's going to be a lot more workload put on the sheriff's office moving forward because we're not holding people in custody in some cases that otherwise might have had their appearance before the judge, and thus we may not have had a need for this. So it's, Greg, unfortunately, I hate to say it this way, it is what it is at this point in time. We're going to have to figure out the best way to move forward and then go back to the General Assembly and say, okay, hey, if we find different aspects of this that do not work or are whatever fundamental issue there might be there, we're going to have to explain it to them and say, we need another fix to this. I don't know. I mean, it has made it through the process to the highest court, and the court has issued its opinion. Whether I agree with it or not, it is the law.
So again, that's Jim Kychek from the Illinois Sheriff's Association sounding off on his reaction and the resources he says are going to have to be increased for those on law enforcement on the ground. But what about the detainable offenses? The Illinois Civic Federation, they put out a list of the detainable offenses back after the change passed in December of last year. And here's what ultimately they have laid out here. In analysis of the law, all non-forcible felonies that are not eligible for probation if the defendant's release poses a real and present threat and safety to any person or persons in the community based on specific articulable facts of the case. All forcible felonies if the defendant's release poses a real and present threat to the safety of any person or persons in the community based on specific articulable facts of the case. This includes treason, first-degree murder, second-degree murder, predatory criminal sexual assault of a child, aggravated criminal sexual assault, armed robbery, aggravated robbery, burglary, where there's the use of force against another person, residential burglary, home invasion, vehicle invasion, aggravated arson, aggravated kidnapping, aggravated battery resulting in great bodily harm or permanent disability or disfigurement, or any other felony which involves the threat or infliction of great bodily harm or permanent disability and disfigurement. So that kind of spells out what is a detainable offense. And they had to go in and change the state law to spell that out clearly. But here's Jim Kychek with more about how this is going to ultimately play out when it comes to a criminal defendant being arrested.
I'm concerned about, threat to the community. I don't know what this is going to create. I think the expectation of the community is that when we arrest somebody for, I'll pick on a retail theft. leave Walmart with a 65-inch TV. It's a theft over. I should be incarcerated for that, held to hear, to go see a judge. Instead, in this case, because unless my criminal history or other issues appear, there's a strong likelihood that I'm going to be booked and released at that point in time, just potentially to be able to go back and do the same act again. And I think that's, those are areas where we're certainly going to have to explore what the impacts are at the local level, how the judges handle this. Do they feel like they have enough autonomy in their own situation to be able to make decisions about the safety of their community? All questions that it will be a learning process. There's no doubt about it. And I don't know that any one process is going to explain it for everybody or be the kind of path that everybody should go down. I think people are going to have to find their own path based on the parameters of the law.
So we'll watch what happens, of course, with local counties and how they handle this. But you've got the Democrats who are emboldened by the Illinois Supreme Court's ruling upholding the Pretrial Fairness Act, encouraging people to hold their county officials accountable. So that was the Sheriff's Association. What about the Fraternal Order of Police? I talked with Donald Hackett. He is the secretary of the Fraternal Order of Police for statewide FOP, and he laid out his initial reactions here to the upholding of no cash bail.
The repeat offender is not going to be able to be incarcerated, and it's not going to take the criminal element very long to figure out how to play the game. And people's well-being, safety, lives will be, they're going to be in peril. And we're not going to say there's going to be murder on every street corner, but what police will not be able to do in 60 days is, I'm not sure that the public has that perception of what's going to happen.
Hackett also talked about a message he has for the general public concerned about their safety and, saying don't blame Illinois police.
When they call the police, and the police show up and say there's nothing we can do, please do not blame the police. This is all on the Illinois General Assembly, and it's definitely not on the Illinois police officers from Rockford to Metropolis and from Rock Island to Danville. This is strictly on the Illinois General Assembly.
Well, and I also asked the secretary of the Illinois Fraternal Order of Police about police morale and what this does to police morale.
I can tell you right now that the morale just got a whole lot lower today with what the Supreme Court decision says. It's difficult enough with the restrictions that House Bill 3653 has placed on law enforcement, and now that the cashless bail comes into effect, we have incredible men and women that serve across the state, and they do their job. They do it with honor and dignity, and now they're going to go to crime scenes, and they're going to look at somebody and say, you got to leave the property, but we can't take you to jail. And they're issued a summons, and the morale is going to be much lower, and we'll see how it plays out. It's easy to say, talking hypotheticals. Well, this is going to happen. This is going to happen. No one really knows what the grim reality is going to be until 60 days from today.
Now it's 59 days from today, so we'll obviously be watching this closely as it gets implemented statewide, but that's the latest back and forth about the no cash bail provision being upheld by the Illinois Supreme Court. Supporters saying it's an historic day, the state being the first to do this statewide. Opponents saying that they're concerned about safety on the streets. It is Springfield's Morning News. I'm Greg Bishop on WMAY. Follow me anywhere, Bishop on Air. Twitter, Facebook, Instagram, YouTube. Just search Bishop on